Hey everyone, I'm going to go through some very basic procedures on transcript requests and state billing. For those of you who have been around a little while, this might be a very basic review and you may know all of this. This is aimed more for new employees who have not experienced billing for transcript requests while employed as an official court reporter. Way back from the beginning, it starts with a case when the defendant is arrested or ticketed, and I am specifically talking about transcript requests for that the state would ultimately end up being a party to. So we're not talking about civil transcripts because the state is very rarely paying for a civil transcript. I will talk on what types of cases that we might pay for, but they are still somewhat criminal in nature. We are only discussing those defendants who were either pled guilty or found guilty by a judge or jury. We'll go from there. So the first thing that's going to happen for something to be a state-provided transcript is that defendant is going to have to be found indigent by the judge. That means they don't have the money to pay for their attorney or transcripts or court fees, things like that, in order to defend themselves. So typically, a public defender is appointed as their attorney after they have been found indigent, and then it'll go from there. So sometimes, in the rare instances, the public defender is not appointed. An attorney might be appointed acting pro bono, so they're not going to charge the defendant. And sometimes it might be a legal aid or service, a nonprofit that covers attorneys for certain indigent cases. So the public defender is usually appointed, but not always. And that doesn't mean if a private attorney is appointed that they're no longer indigent. It's just that they are going to be represented by someone else free of charge. So sometimes during this trial, a transcript request will happen. It might be the public defender. It might be the state's attorney's office if they need it to help them prepare their case or prepare motions, things like that during the trial. In most cases, these are not the transcripts the state would pay for. We can't say what the county will pay for, but in most situations, the public defender's office or the state's attorney's office has their own budget for transcripts, and those would not be billed to the state because we're not yet on appeal. There are some statutes where the state will pay for transcripts that will go into the case file. The one thing here that you can remember, if the defendant's attorney is asking for it, or if the state's attorney is asking for it, chances are the state is not paying for it, because prior to appeal, the ones that the state has the authority to pay for are ones that are going to go into the case file, not to a person. So transcripts that are paid for the state, they always go in the case file, and we typically will only pay for it once because we're paying for that one copy in the case file. So even if it goes on appeal later, it should still be in the case file. Therefore, the state is not going to pay for that transcript twice. There are some exceptions, and we'll talk about those on following screen. So the defendant is found guilty, and in most criminal felony cases, there's going to be an appeal. So the defendant is guilty, whether he entered a negotiated plea of guilty or whether he was found guilty by a judge or jury. Then in most felony cases, there will be an appeal following the sentencing hearing. We don't just pay for felonies, so it's not just that situation. If somebody has been found indigent and it's a traffic case where they have a sentence of probation or of supervision, or if it's a DUI and they've been found guilty, mental health cases, or there are juvenile cases. So these are different case types, but they are all treated the same way. If the person is indigent and the person is appealing, then the state provide transcripts for that appeal. So if the defendant is not indigent, the state does not pay. So that's your first key on whether the state's going to pay. In a large percentage of felony cases, the defendant has been found indigent, so that takes care of a lot of those things. Typically, the state appellate defender's office would then be appointed to handle the defendant's appeal, and they'll be their attorney. Occasionally, an indigent defendant would have a private attorney appointed, legal services, or possibly represent themselves pro se. Who is representing the defendant does not affect their indigency. So that does not affect the state paying for it. In order for the state to pay for a transcript for the purpose of an appeal in these criminal case types where the state's a party, the defendant must be indigent and appealing. So who's representing them does not change the fact that the state would pay for it. Now we're going to question, if we see a private attorney come through on the billing, we are going to question whether they are indigent. So make sure that you have provided documentation showing they're indigent. If you're not providing, say, a letter from the state appellate defender's office, we're going to need to know that they're indigent. So that has to be covered in another document that's attached to your billing. So these are the questions you're asking before you decide to bill for the state. Number one, is the case on appeal? There's going to be a court order stating that it's on appeal, a copy of a notice of appeal from the circuit clerk's office, a letter of request from the state appellate defender's office, or a docket sheet showing the appeal is filed. Now, if you're providing a docket sheet and that page does not show that they're indigent, we will also need the page showing they're indigent. We don't want the whole docket, everything in between. And we prefer that the relevant parts be highlighted if you're providing a docket, meaning we need to see notice of appeal filed, and that should be highlighted. And we also should see indigency or something highlighted that covers both the appeal and the indigency. The next question, is the defendant indigent? The letter from the state appellate defender's office, that counts as showing indigency. And just like I said with the docket sheet, we're going to need to see something also showing they're indigent. The copy of the notice of appeal from the clerk's office, if it says that the state appellate defender has been appointed, that covers indigency. And if it's a court order signed by the trial judge, both of those things should be in there. It should say that they are indigent, and it should say that they are appealing their case. The last check is the state a party to the case? So we're talking people versus the defendant's name. So that's criminal felonies, misdemeanors, DUIs, traffic, mental health. Mental health can be a respondent instead of a defendant. And then juvenile delinquency cases, they're very much handled in the same way as a criminal felony. The only non-criminal appeal that we accept and we will pay for the transcript is an MR case in which the person has been declared a sexually violent person. There's other ones that are close to this, like sexually dangerous person. There is no provision that allows the state to pay for sexually dangerous, only sexually violent persons. So the court order that you provide or whatever proof of appeal has to state sexually violent persons if it's an MR case, or that will be kicked out as the state is not responsible for it. Here are some common things that might be questioned that the state will not pay for. Any civil case except for sexually violent persons. Juvenile abuse and neglect cases, there is a specific statute set up that says that the county pays for appeals in juvenile abuse cases. And then cases that are not yet on appeal, even if it's ordered by a judge, unless one of those specific statutes or Supreme Court rules is cited in the order, which says that the state is allowed to pay for it. So just because a trial judge orders a transcript for the defendant, it doesn't mean that the state is going to pay for it if it's not yet on appeal. So the next step is after you complete that appeal, you're going to bill the state for in the CTF program. The things I want to point out about CTF, there are videos that go in depth on how you work CTF. So I'm not covering that in this presentation. This is strictly what you can and cannot do. You can only bill the state the original rate once for a transcript, no matter how much time has passed. So if you're entering a transcript billing and it pops up as a duplicate or a possible duplicate, and you look at that and see that you have billed at $4 before, you cannot bill again at $4. You can bill at a copy rate of 50 cents a page for the same transcript in only two situations. One is for a co-defendant's appeal. So you filed the transcript on John Doe, but now Jane Doe is also appealing, but not together. You would then charge 50 cents a page for that same transcript that you already billed for John Doe. Or the second case for John Doe, he has two case numbers. The first one, they're both being appealed, so you bill the original in the first case number and e-file that one, and then you bill the copy in the second case number, and you can bill 50 cents a page for that. Now, if the second case number is not appealing and it's not on the appeal order, you can't bill for that second case number. So both of them need to be appealing. Even if they're separate or together, doesn't matter. We need to see both case numbers on the appeal order, or we can only pay for the one that is on the appeal order. In all cases, what the state pays for, it must go into the case file because that's what the state is paying for. The defendant's copy are provided free of charge per a Supreme Court rule. So if anything on your payment request says the defendant's copy, then we can't pay for that. It has to be what's going into the case file for the purpose of appeal, or what's going in the case file because those admonishments needed to be made part of the common law record and you were ordered to put them in the case file. Those are the ones that we provide. The original rate that the state pays for is intended to cover the defendant's copy. For those of you who haven't been here around for a few years, the rate used to be $3 a page for original plus 50 cents a page for the copy, and we provided an original and a copy. So you essentially got $3.50 a page prior to electronic filing. Now that we have electronic filing, we up the rate to $4, and that also includes the defendant's copy when the state is paying for it. The one thing that I would like to point out is that defendant's copy being free of charge is only a provision that applies to state billing. It doesn't necessarily apply to a municipality who wants an original and a copy from you, or the AG's office that wants an original and copy for you. Let me point out, the AG's office is a state agency. However, I'm only talking about the transcripts that get billed through CTF. If the AG's office is requesting a transcript from you, that billing would go through the AG's office, not through the CTF system. So I mentioned briefly the duplicate flags in CTF, and I want to go into it a little more here. It's pretty common for something to flag as a duplicate in CTF, but not be the same transcript. So I'm going to kind of explain how that happens. What the flag is it's just a check saying that you have previously billed for a transcript that was in this courthouse on this same hearing date. And as you know, you can hear a lot of cases throughout the day. So all you have to do in those cases when they're unrelated is clear the duplicate flag by marking the reason why it's okay to be billed. So the most common thing is it's not a related case. Those were two unrelated cases heard at different times on the same day. So you would just check not a related case, and that would clear the flag, and you would move on. Now, there's two types of related cases. One, it's a related case because you're billing for a copy for the co-defendant or billing for a second case number, and then you're going to comment to explain, and you're going to provide the co-defendant's name that's already been billed under, or the other case number that it's already been billed under, and that you're just charging the copy. The next one is it's the same case, but a different portion of the same day. So the example here is you submitted a transcript for appeal, and that was only the AM portion of the day, and you didn't realize there was a PM portion that was separate. And say you only billed for the AM session, but they requested the PM session in a supplemental or something. As you're coming through, you're going to pull that up, and it's going to match on case number and hearing date. So it's going to be very hard to explain that without putting additional information. So you would mark same case, different portion of the day. And in the comments, you're going to need to explain that you previously billed for the AM portion, but now you're billing PM, or whatever the situation is, because you're, in this case, since you haven't billed it before, you're going to be billing an original page rate for the same case on the same day. And unless we have a very specific reason why that's okay and how that's not the same transcript, even if the pages are different, we need a good explanation for accounting and audit to let that go through. So the more information you can explain on that, the better. And then there is an other, just for anything that we can't predict, because as you all know, after you work for a while, there's always this weird situation where it's not a normal thing. So I can't think of anything right now off the top of my head, and other shouldn't be used very often. So if you're picking other, you need to question if it doesn't better fit in the top 3 choices. But when you put other in there, we're going to need a really good explanation so we don't have to call you to try to figure out why this other reason for the duplicate is okay. And if you are filling out another, you may want to touch base with Court Reporting Services first to make sure that it's something that sounds okay to bill, and save everyone's time from it going through all the checks and then getting to us for a rejection. Just go ahead and give us a call or an email and check on it first. Say, this doesn't quite match. It's a weird situation. Send an email. Let us know the situation. Good thing would be to attach the documentation that you got when you ask that question, because lots of times that's going to be the first question we have is, who ordered it? Why? Let us see the documentation. So send that along with an email to Randy, and I have her email at the end of this session, and ask her if this is something that looks right to her before you put it into CTF. The next thing I want to point out to you that I think people forget a lot is that in the back of the administrative regulations, there is actually a table that goes through and describes every type of case that the state of Illinois will pay for. The ones that are most common, of course, are the appeals, and that's what's in the screenshot there. Standard appeals, post-conviction appeals, JD appeals, mental health appeals, and sexually violent persons. Those are the common ones that come through. Now, there's some weird ones like appellate court orders. They're down there. An appellate court order, typically the case is on appeal, but on occasion they want a co-defendant's transcript that hasn't appealed. So say one co-defendant was acquitted and the other one was found guilty, lots of times they'll want a co-defendant's transcript. So that's not quite a standard appeal. Sometimes those will come through on an appellate court order or an order from the appellate clerk's office. Those are things that happen, not often, but they happen. And I've also, on the right side there, it mentions arraignment. Sometimes that is ordered to go into the case file. And the one thing that you need to keep in mind here is that the arraignment can only be billed once. It's also a part of the record on appeals. And so if you are charging for the arraignment and later the appeal comes, you can't charge for that transcript again because it's already in the case file. The other things this table will tell you is it gives you our statutory authorization or Supreme Court rule, the citation that allows the state to pay for it. It gives you a synopsis of the description of what's going on, and then it also describes CTF documentation. The one that is most flexible is the appeals, because it gives you 4 different kinds of documentation that you could provide for the purposes of appeal. Later, if they're not appeal, it's going to be a court order, and that court order is going to have to be very specific, and the court order should reference the authorization for paying for the transcript. This reference is very helpful when you get something that's not a standard appeal. So I would recommend if you have something that's a little weird, that you go to that administrative regulations document, which can be found on our website under resource documents in the employees section. So check out the table in the back and make sure that it looks like something that fits that situation for you. And if in doubt, what I've always said is really the court reporter shouldn't be determining whether there is a transcript that is required. Realistically, I know that court reporters type a lot of the court orders for the judges, but if the judge is not initiating a court order, or if it's not standard practice in your circuit that you prepare the court order because you already know the judge is ordering it, it's not a court reporter's duty to figure out what goes in the case file. It needs to be court ordered by a judge. Finally, if you need support in CTF, you're going to contact Randy Lucas, and Randy's email is randy@ilcrs.com. She is our main CTF support person. So if you have questions that have to do with CTF, talk to Randy first. Sometimes I still get questions on my email about something in CTF, and Randy would be your first point of contact. So save yourself some time by emailing her first, because I'm just going to reply to your emails and refer you to Randy. Provide as much information as you can, including documentation about your request, the documentation or request that you received, and then she can review that and get back to you. If you have questions, start with Randy. Thanks for listening.